table. She's gonna run.
Get back! That's another 30 days. That's 60 days.
And if you're too stupid to know that what I'm trying to do is protect you.
This is Joseph Jerome Baton.
Okay, next fellow would be Joseph Jerome Baton.
He is facing trespassing charges after an incident at a local track and casino located in Fort Lauderdale, Florida.
Good morning, Your Honor.
Good morning.
I do have a history, Your Honor. Can I speak to you, Your Honor?
Baton is a repeat offender, having been caught trespassing twice in just the last 2 months. In fact, he has been convicted of trespassing over 10 times in the past 2 years. As a result, he is quite familiar with the bond court scene and shows no interest in resolving his case.
I already know I got a history. This man ain't said nothing to me now time in here this morning. All right, Your Honor? And I'm just being frank with you. That's the only place I go. Only thing I do, as you can see, is nothing but trespassing, because that's my only entertainment, all right, is go to the track, and I like for you to make an offer. And if I like it, I accept.
Despite the advice from his public defender, be ready for a twist in the case that will leave you stunned.
You discharging your public defender at this time, sir?
No, I ain't discharging, but he ain't presented the way I wanted to be presented. I ain't say resolve it. I said make an offer, which is how much time, whatever is 2 weeks, 3 weeks, I want to resolve it in that frame, in that fashion, sir.
The attorney attempts to interject and steer the conversation back to the matter at hand, but Baton consistently interrupts, refusing to let him speak.
I've explained to Mr. Baton not to talk about the facts of the case. Ain't no facts. We ain't going to trial. I'm asking you to make an offer, Your Honor, straight up. It's the history, proof is in the pudding. That's the only thing I got. As you can see, ain't nobody been hurt. I ain't never intoxicated when I'm arrested, so it ain't nothing. You know what I mean? All it is trespassing, simple trespass.
Surprisingly, Judge John Cantini found Baton's arguments compelling, resulting in a 45-day jail sentence at the Broward County Jail.
I respect your request, sir. I'm going to go ahead and offer you a chance to be, if you were to plead no contest at this time, sir, I would offer you an adjudication. You'd be convicted, of course, as you have indicated you have many of those already, and you'd be in, the plea offer would be 45 days in the Broward County Jail.
Baton believes his sentence should be shorter and provides reasons to support his belief.
Well, nah, I ain't gonna accept 45 days, because I did 30 days last time, just a week ago. But my birthday coming up, I'm hoping you can say a week or two, and I agree with that, you know what I mean?
Despite Baton's argument for a shorter sentence, Judge John Cantini remained firm in his decision. Baton respected the judge's decision, but declined the offer. Instead, he took his chances with a different judge, pleading no contest and receiving a lighter sentence of just 17 days in jail. Joshua Martinez is facing charges of driving with a suspended license in Las Vegas, Nevada. During his court appearance, where he represented himself, Martinez requested to clarify a few points before entering his plea when the judge asked for it.
I have a couple questions before we proceed. I don't understand the nature and cause of the charges.
You're charged with driving on a suspended, canceled, or revoked driver's license, sir.
Okay. Is that a criminal offense or
It's a
civil?
criminal offense, sir.
Criminal? Okay. Is there a sworn statement against me or injured party?
I believe you probably received a citation on April 12th. That would be the criminal complaint filed against you.
Joshua Martinez sought to understand the nature and cause of the charges against him, believing there might be a legal technicality he could exploit. However, the judge, unwilling to entertain Martinez's diversion, plainly explained that he was charged with driving on a suspended, canceled, or revoked driver's license.
The city is the charging party.
So they're the victim?
Sir, the victim element is a different legal term than is used.
It might seem straightforward, but for Martinez, it wasn't. He began questioning the judge, probing further into the details of the charge and the circumstances surrounding his case.
What is your plea on the
If the
charge?
city
Mr. Martinez,
if they are the
today is
victim,
Mr.
I would like
Martinez,
to
I am in
move
charge
this
of
to a
this
federal
courtroom,
court.
and you're going to stop
No, we
interrupting.
are in charge of the courtroom, ma'am.
Marshall, would you show Mr. Martinez the inside of our holding tank, please? You're not going to tell me who's in charge of my courtroom.
The judge reached her limit. Determined to assert her authority in the courtroom, she addressed Martinez's behavior directly. After about 20 minutes, Martinez was brought back before the judge, this time to be sentenced for a newly acquired charge of contempt of court.
Okay, Mr. Martinez, since you have informed me that I am in contempt of court and that you are in fact in charge of this courtroom, I'm going to go ahead and sentence you today to direct contempt of court. I will give you an opportunity to apologize if you choose to do so, and behave in a manner that I consider appropriate for a courtroom. Would you like to do that today, Mr. Martinez?
I would like to proceed only if I can have my questions answered. That's all I
That
wanted.
wasn't my question, sir. Did you wish to have the opportunity to apologize and proceed in a manner that I consider appropriate for the courtroom?
What would I be
It is a
apologizing?
yes or a no question.
What would I be apologizing
For
for?
your direct contempt of court, sir.
All I was asking was legal questions, ma'am.
I disagree, sir. To tell me that you are in charge of this courtroom and tell me that I am in contempt is not asking legal questions. It is contempt of court.
Martinez attempted to argue his case by invoking his Sixth Amendment rights, but by that point, it was too late. The proceedings had moved on, and the focus had shifted to addressing his contempt of court. This case involves Ebony Burks, a 32-year-old woman charged with domestic violence and assault in Ohio. During her appearance at the Elyria Municipal Court, Judge Gary Bennett informed Ebony that she was prohibited from contacting the victims involved in her case. It was at this moment that the situation took an unpleasant turn.
I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Tiffany Castro. No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with
I'm talking. I don't need you to say nothing.
if you live with Mr. McCrae, you cannot return to that residence.
Ebony was particularly upset by the restriction that prevented her from contacting her grandfather, Shedrick McCrae, with whom she lived. This directive caused her to lose her composure, and she began to argue with Judge Gary Bennett, directly challenging his instructions.
How you gonna tell me I can't go to my house?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not what?
Whoa.
Get back! Get back!
You just said I got
Get
30 days.
back!
I'm not getting nothing else.
That's another 30 days. That's 60 days.
Initially, Judge Bennett issued a 30-day sentence for contempt of court, hoping it would resolve the situation. However, Ebony continued to speak aggressively and argue with the judge, prompting him to increase her sentence further in response to her continued defiance.
Got anything else to say, Miss Burks? That's 300 days!
As Ebony persisted in speaking out and arguing, Judge Bennett escalated the situation by increasing her prison sentence for contempt of court to 300 days. Arthur Hage, a church pastor, and his estranged wife, Lillian, were in family court in Putnam County, West Virginia, for a divorce hearing overseen by Judge William Watkins III. The proceedings began with Judge Watkins sternly warning Hage to behave appropriately in court. However, the situation was complicated by Hage's refusal to sign a deed that would allow for the sale of their marital home.
Mr. Hague, if you say one word out of turn, you're going to jail. Do you understand me? Yes or no?
Watkins was already angry with Arthur Hage because Hage had disclosed personal information about him to the media.
Morning, I now see an article from your little buddy, Smith, with a picture of my home. My home.
Even though Hage's name was not mentioned in the article, which primarily focused on Judge Watkins' involvement in a local homeowners association, Watkins continued to express his outrage during the proceedings.
Disabled, she's there alone, and you disgusting.
During the proceedings, Judge Watkins even threatened Hage.
You are responsible. I'm holding you personally responsible for anything that happens at my house. I promise you, if I so much as see somebody breaking at my home, my wife, my family, you and me are going to have a problem. It is personal. You have threatened my family. And I promise you, you will not hear the end of it from me.
After giving Hage a piece of his mind, Watkins regained his composure and refocused on the divorce case at hand.
Sorry, Miss Wallace, Miss Hague, I'm sorry, I cannot tolerate that circumstance.
Eventually, Judge Watkins ordered Hage to sign the deed and also mandated him to pay $500 to a third party to accelerate the process.
Mr. Hague, pay him the sum of $500 for his services no later than Friday.
However, Hage disagreed with the ruling.
I'll sign it. I don't have that kind of money. I don't have the money.
Despite Hage's objections, Judge Watkins ruled in favor of Lillian Hage, ordering the pastor to cover several expenses once the house was sold. Unhappy with the outcome, Hage later filed a complaint against Judge Watkins with the Judicial Investigation Commission. Subsequently, it was revealed that Judge Watkins had a history of berating litigants and attorneys in his courtroom. This led to his censure for 24 violations by the West Virginia Court of Appeals, and he was ultimately suspended without pay for the remaining 4 years of his term. The crimes committed by Eldon are indeed unacceptable, but their behavior in court is even more chilling, likely to shock anyone observing the proceedings.
Henry T. Eldon, Henry T. Eldon, Henry T. Eldon. I have called him thrice. I have no response. Get up here in this seat right now.
The court reporter has to be established before anything can proceed.
Henry identifies as an American national, subscribing to the sovereign citizen belief that he is above the common laws of his country. Listen carefully as he explains his perspective.
I'm not acting. I'm a witness. This is an American national.
Eldon was accompanied to court by a friend, also a member of the sovereign citizen movement, who recorded the entire proceeding on his phone and even defended Eldon's disruptive behavior in court.
I'm a witness today of this. Okay. I'm a witness, okay? Okay, what I'm saying is he is present, and he's chosen not to step up there. He's asking not for an appointed lawyer. He doesn't need an attorney, okay? So I'm just a witness that he is present here, okay? And I will repeat that when the court reporter begins. For the record, I'm a witness. Sit down. This is Ted Eldon. You sit down, not say another word. That's Ted Eldon.
After some back-and-forth exchanges, Eldon reluctantly and only partially complied with the judge's orders. However, having had enough of Eldon's defiance, the judge decided to take further action.
You are going to be held in contempt.
All right, Mr. Ellen, can you just stand up for me, please? Turn around and place your hands behind your back, if you would.
And who are you? And do you have a warrant, a signed warrant?
I do not have a warrant. I've just been made aware by the judge that he wants me to take you into custody for obstructing judicial process, okay?
Eldon escalated his defiance by demanding to see the oath of office, acceptance letters, and acknowledgments from both the judge and the prosecuting attorney. He also insisted on knowing the names of everyone present in the courtroom. At the next scheduled court hearing, Eldon failed to appear, leading to the issuance of a bench warrant for his arrest. Consequently, he was sentenced to 2 weeks in jail. Shawn Blitchington, a 48-year-old struggling with alcohol addiction, had a troubling history before 2018. He had been arrested 5 times for driving under the influence, resulting in the revocation of his driving license. Despite this, Shawn continued to drive and drink. On July 22, 2018, after consuming excessive alcohol, Shawn Blitchington took to the streets in his truck despite having his license revoked. In an intoxicated state, he drove on the wrong side of US 301 in Bryceville. This reckless maneuver resulted in a tragic collision with a vehicle carrying 21-year-old Ryan Kennedy and 22-year-old Bailey McKnight. Both Kennedy and McKnight were killed instantly. The impact of Blitchington's actions extended beyond these immediate fatalities, deeply affecting the community and the families involved. After the crash, Blitchington fled from his vehicle, but was later found by the police hiding in a ditch and was immediately arrested. Shawn Blitchington faced charges of driving under the influence, manslaughter, driving on a permanently revoked license, and leaving the scene of a fatal crash. During his trial, Circuit Judge James Daniel emphasized that Blitchington's decision to drive drunk was intentional and had catastrophic consequences for the families involved. In her victim impact statement, Susie Kennedy expressed profound grief, stating she felt as if she had died that day too, but was left unburied. She labeled Blitchington a thief for robbing her of precious future moments with her daughter and grandson, Lawson. Blitchington expressed remorse and apologized to the victim's family. He was ultimately sentenced to 60 years in prison, meaning he would be 108 years old by the time he completed his sentence. Judge John Woolley is presiding over the case of a 16-year-old defendant who violated his probation in a juvenile court in Vancouver, Washington. The teenager, accompanied by his mother, but without his attorney present, shocked everyone when asked about his attorney's whereabouts by expressing his desire to represent himself.
I'd like to fight for myself.
However, Judge Wool disagreed with the teenager's decision to represent himself.
That's not a smart play. That's like going out on the field with the New York Yankees and you've never even learned how to play baseball.
Despite the teenager's insistence on representing himself, Judge Wool maintained that he should have legal representation. He clarified that legally, a juvenile cannot plead guilty without an attorney assisting in the proceedings.
I'm not going to do that. You're going to have an attorney assist you in this matter.
But I'm not going to let him fly solo and walk into a court of law and try to practice law.
The teenager attempted to reason with Judge Wool. Still, the judge emphasized the importance of his role in protecting the defendant's constitutional rights, particularly stressing that these protections were in place, even if the defendant did not fully understand them.
We're sending it over to Tuesday.
The court clerk attempted to signal the teenager and his mother to be quiet as they began to speak, but the confrontation quickly escalated. Judge Wool, visibly frustrated, ultimately lost his temper and bluntly expressed that he was trying to help the defendant.
I'm doing my job, sir. My job requires that I protect your constitutional rights. You as an American citizen. That's my charge. And if you're too stupid to know that what I'm trying to do is protect you.
Moments later, Judge Wool apologized, acknowledging that he rarely lost his temper.
My apologies to everyone in this courtroom. I very rarely lose my temper, but when I do, it's usually because someone is too stupid to recognize that I'm trying to help them.
Judge Wool's apology appears backhanded, and his assertion that he rarely loses his temper isn't entirely accurate. Over a 2.5-year period, Judge Wool was cited for multiple incidents of discourteous and impatient behavior. Ultimately, his courtroom conduct led to a public reprimand by the Washington State Commission on Judicial Conduct. In Shelbyville, Kentucky, a divorce hearing has taken a heated turn. The husband has filed a motion requesting that his ex-wife be mandated to secure her prescription narcotics inside their shared home, where they reside with their children.
And they're wise enough not to go around taking... I only interviewed the children for a few minutes, and I get it that they're okay with not taking... Your children are very bright, and I can't even believe you would make that motion.
The attorneys brought to the judge's attention that one of the children had expressed thoughts of hurting themselves during the divorce proceedings, raising significant concerns about their mental health.
I can appreciate what you're saying. They are good children, but there has been some mental health concerns, and we just think it's good practice to do that.
Even with this concerning information, the judge remained unconvinced, insisting that there was insufficient evidence to support the need for securing the prescription narcotics.
It's not a year-old who'll pick up a pill off the floor.
The frustrated father presented a reasonable counter-argument, but the judge remained unconvinced and did not accept it.
Your opinion on that, I'm sorry, is just wrong. Intelligent children have a risk just as well as unintelligent children.
You have no evidence to put before me that these listen, you need to stop talking. You
sorry.
Really do.
I disagree with you on that.
Well, fine, you disagree, but you're not up here. I've ruled on that.
Unable to hold back his opinion any longer, the father had something to say to the judge. The judge promptly held him in contempt of court and reprimanded him for his behavior.
Contempt of court. You don't tell me that I'm ridiculous. Do you understand me? Have a seat over here, bailiffs.
The bailiffs escorted the father to a seat in the courtroom, but the passionate father refused to give up. He continued to plead his case, emphasizing that the well-being of his children was at stake.
You heard yourself that one of my children talks about committing. Yeah, they're in a house full of narcotics that are unprotected. Do you not see that that could be an issue?
He pointed out that having unsecured prescription narcotics around children could pose a serious risk. However, the judge remained firm and dismissed his concerns. Lee Rios is facing charges of murder in Massachusetts, USA. In 2015, Rios and Jonathan Guerra, both members of the Latin King Street Gang, murdered 18-year-old Kenneth Lopez. The murder was strictly ego-driven. Rios believed he had to kill Lopez because he felt disrespected, showcasing the dangerous consequences of gang-related violence.
Mr. Lopez lost his life because he had hit on Mr. Rios' ex-girlfriend and because he showed him disrespect.
Rios lured Lopez out of his house, and they shared a cab to the the location where Lopez tragically lost his life. Upon arrival, they were joined by 3 other Latin Kings gang members. The assistant district attorney, Max Bennett, informed the court that Rios fired a total of 5 shots, with 4 of them striking Lopez, including 2 fatal shots to the head. Rios's actions were already heinous, but his demeanor in court was also less than desirable. He appeared disinterested in the proceedings. Despite denying the charge in Springfield District Court, the case proceeded to Hampton Superior Court. Rios was ultimately convicted of first-degree murder by a jury and sentenced to life imprisonment without parole.
Count 1. Jury having convicted you of first degree, sir, I'm sentencing you to NCIC conjunction for the term of your life without the possibility of...
Rios's cold demeanor and lack of remorse serve as a reminder of the destructive path that comes with involvement in the gangster lifestyle. Witness the chaos as Call of Duty and similar games turn the battleground beyond screens into all-consuming addictions.
Count 7 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did Dorothy Brown. If guilty of this offense, it is a felony punishable by up to life in prison.
On February 20th, 2016, a heartbreaking cacophony of chaos unfolded in Kalamazoo County, Michigan. 8 lives were shattered by gunfire, and 6 souls were tragically lost. Amidst the wreckage, one name echoed: Jason Dalton. Overwhelmed by grief, mourning families sought justice in the courtroom, their silent agony echoing through the halls.
My name is Lori Smith. And Richard was my husband, and Tyler was my son. My husband was my best friend, my soulmate, the love of my life. He was my person. On our wedding day, he surprised me and had a song called "Forever's as Far as I'll Go" played for me. To this day and beyond, I love him with every ounce of my being. Our love for each other is for eternity, and no one can or will ever change that. No matter what life threw our way, we were always there for each other. He was a loving, caring, thoughtful, and intelligent man who would do anything for anyone. He was a friend to everyone. Rich had a laugh that was contagious. He loved to make people laugh. He always knew just what to say and what not to say and when. He made me laugh. He held me when I cried. He told me everything would be okay when times were tough. And he was always there, no matter what. We started out remodeling houses together. Then we got married and had children. I always counted on him and him on me. We were a team, as soulmates, as parents, and as friends. Our kids were our world, and Rich was an awesome father. His kids and I came first. Everyone who knew him knew that. Whatever the kids had going on, we were there. And when schedules overlapped, he went to one kid's event and I went to the other. Family and friends often came to us when they had a problem or needed help, and he and I would team up and took care of whatever needed to be done together. One of the things we loved to do is to go up to Silver Lake, Michigan as a family, with my extended family too, and play on the sand dunes and around camp. Rich had grown up around ATVs, dune buggies, and off-roading, and loved to share his passion. Rich and I had plans for the future. We were going to go places, discover things, continue to make memories together, continue sharing in our kids' lives, being a part of their futures as they finished school, started families on their own, and realized their dreams. My son was loving, caring, funny, smart, and thoughtful. He too was a friend to everyone, including me. I could not have been more proud of him and the respectful young man that he was. I love him to the deepest of my core. He was and is my precious baby boy. His smile lit up the room, and he often greeted loved ones with rib-crushing hugs. Tyler was a very talented athlete and could do anything he put his mind to. He loved his family, and I have a big family, and we all loved each other very much. Tyler was especially close with his sissy, as he called her, and with my twin sister's 3 kids. In fact, my twin sister's 3 kids were more than just cousins. They were siblings. They all grew up, went to school, and did practically everything together. They were very similar in ages. Tyler's friends were important to him too, and that includes his girlfriend, Alexis. Tyler told me when he first met Alexis that he wanted to do things right and not screw it up with her.
When confronted with their own criminal behavior, individuals may fail to recognize themselves, but their reactions can often be discerned from their eyes and facial expressions.
By a sentence up to life imprisonment. Count 2 of the complaint. It's alleged that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did carry or have in his possession a firearm, to wit, a pistol, at the time he committed or attempted to commit the felony of murder. If guilty of this offense, it too is a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 3 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did murder Mary Jo Nye. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 4 alleges on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did carry or have in his possession a, to wit, a pistol, at the time he committed or attempted to commit a felony, that being open. If guilty of this offense, it is a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 5 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, the defendant did Barbara Hawthorne. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 6 alleges that on February 20, 2016, in Kalamazoo County, State of Michigan, Texas Township, that the defendant did carry or have in his possession a pistol at the time he committed or attempted to commit the felony of open murder. If guilty of this count, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 7 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did Dorothy Brown. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 8 alleges at that same time, date, and place that the defendant did carry or have in his possession a pistol at the time he committed or attempted to commit the felony of open murder. If guilty of count 8, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony. Count 9 alleges that on February 20, 2016, in the city of Kalamazoo, Kalamazoo County, State of Michigan, that the defendant did murder Richard Smith. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 10 alleges at that same time, date, and place that the defendant did carry or have in his possession a at the time he committed or attempted to commit the felony. If guilty of this offense, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 11 alleges that on or about February 20, 2016, in the city of Kalamazoo, Kalamazoo County, State of Michigan, that the defendant did Tyler Smith. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 12 alleges at that same time, date, and place that the defendant did carry or have in his possession a firearm at the time he committed or attempted to commit the felony of open murder. Guilty of this offense, it's punishable by up to 2 years in prison consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 13 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did make an assault upon A.K. a minor child with intent to commit the crime. If guilty of this offense, it's punishable by life or any number of years. Count 14 alleges at that same time, date, and place that the defendant did carry or have in his possession a at which time he committed or attempted to commit a felony, that being assault with intent to. If guilty of this offense, it's a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 15 alleges that on February 20, 2016, in Richland Township, Kalamazoo County, State of Michigan, that the defendant made an assault upon Tiana Carruthers with the intent to commit the crime of murder. If guilty of this offense, it's punishable by up to life or any number of years. Count 16 alleges at that same time, date, and place that the defendant did carry or have in his possession a at the time he committed or attempted to commit a felony, that being assault with intent to murder. If guilty of this count, it is a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction.
Humans can occasionally serve as psychopomps, guiding others to confront their mortality when faced with someone they attempted to harm or kill.
A couple minutes go by and we don't even make it to the park almost. We're like right there by the sidewalk. And I seen him coming and I saw it.
No. They gave bags, these old people, they have these old black bags, they're called they're black bags, and people drive around and look at them. It gets real, like, hey, it's time people look, and then that's when to tell people it's time to get to temple.
Joe, you need to listen to your attorney.
Yeah, you need to get to temple because you need to get going, because it's called intimidator bags.
You need to be quiet in today's proceedings, okay?
Yeah.
If you have anything to say, you whisper to your attorney. That's today's rules, okay? Okay.
So, Ms. Carruthers, are you okay? Or do we need to take a minute?
All right, we're going to call a recess.
Take it!
Court, you're holding. Come on.
We're here, honey. You're okay. You're okay, baby. You're okay.
In the chambers of justice, where fate hangs in the balance, the firm boom of the gavel awaits, ready to tip the scales of righteousness should guilt be proven.
And secondly, are you prepared at this point for the court to engage in sentencing? It's a preliminary matter. I would note that a number of people have spoken to me outside of court, and I've heard now in court the question, why? And that, as best the court can see, is only going to be known to you and to our Creator. What I can also say is that by your actions, Kalamazoo has been given an opportunity to show the world, the words of Archbishop Tutu, that goodness is stronger than evil. love is stronger than hate, that light is stronger than darkness, that life is stronger than that victory is ours because of him who loves us. It's a court sentence as to counts 1. I have to go through each of them individually. Count 1, that you, Jason Brian Dalton, be remanded to the custody of the Michigan Department of Corrections and be sentenced to a period of life in prison without the possibility of parole. This is to be served consecutive to those sentences that will be given in counts 2, 4, 6, 8, 10, 12, 14, and 16. Also, they are to be concurrent. It is to be concurrent with counts 3, 5, 7, 9, 11, 13, and 15. As to count 1, you are to be assessed indigent defense fund fee of $1,795, court costs of $1,000, $130 crime victim fee, and $68 state costs. If there is, in fact, restitution that's owed, that is left open at this time upon application of certain institutions. I would take the opportunity to note that as part of the process of this community pulling together, a number of funds have come forward to assist the victims in their medical and ancillary costs. Those institutions, I believe, should be given an opportunity to recoup such funds as they can from you. Plus, if the victims have additional costs associated with the crimes in which you were convicted, they should be allowed likewise to assess those costs against you. As to count 2, court will order that you, Jason Brian Dalton, be remanded to the custody of the Michigan Department of Corrections for purposes of classification and incarceration for a period of 2 years. This is a mandated offense, and this sentence is to be imposed or is entitled to have credited 1,080 days that you have currently served. This is to be concurrent with counts 4, 6, 8, 10, 12, 14, and 16. In addition, the court is going to order that you pay $68 state costs for that count. As to count 3, the court will order that you, Jason Brian Dalton, serve a period of incarceration with the Michigan Department of Corrections for life, as is mandated, and that is to be consecutive to counts 2, 4, 6, 8, 10, 12, 14, and 16. It is to be concurrent with sentences imposed in counts 1, 5, 7, 9, 11, 13, and 15. And there is, in fact, a state cost of $68 imposed as to that count. Count 4 is also what's called felony count. You, Jason Brian Dalton, are to be remanded to the custody of the Michigan Department of Corrections for sentencing. Period of 2 years as mandated by statute. That sentence is entitled to 180 days credit, and it's to be concurrent with sentences imposed in 2, 6, 8, 10, 12, 14, and 16.
Youth's fiery passion burns bright, but escaping reality through consumption won't spare you from the consequences.
First and foremost, again, and I know I can't say it enough, I'm sorry to the Webbers. I'm so sorry.
On July 26, 2015, in Sterling Heights, Charles Weber rode his Harley-Davidson straight to court after taking a man's life. Let's uncover the incident of his fateful bike journey. There might be hesitation in apologizing for a crime that results in the loss of an innocent life.
After the incident, by not stopping immediately. That jumps him from the 19 to the 20 to the 29. And I know that the guidelines are not mandatory. And you will follow, you will make your own decision, Judge. I've discussed with Nathan, I saw that he was screened for PA 511. Here, and I would ask that you consider placing him in county jail for the 12 months and upon release being ordered to complete a program, the boot camp program through the Department of Corrections, the SAI. This is a 90-day program followed by another 4 months of hard work and sweat and labor. And Nathan is willing to do whatever he can, Judge. I would ask that you consider doing that so Nathan can serve his time and we don't lose two people here. Mr. Weber can't come back. Nathan can, and he will. If Your Honor doesn't feel inclined to go that route, I discussed this with the assistant prosecuting attorney before we went on the record. There was no plea here. He pled straight up, asking for low end of the guidelines. But it's my understanding if there was a HIDA added today, he could be sentenced to prison with your ability to pull him back and still put him into this boot camp program because it would be conditioned through the HIDA. I know that Nathan would like to make a statement to you, Judge. I know that ordinarily you're not necessarily going to let a family member speak, but due to the gravity of the situation and everybody that's here for Nathan, I would ask that you allow his mother and father to speak, not both of them, but if his mother can address Your Honor, that would be sincerely appreciated by the family.
Mr. Hunt.
Your Honor, July 26, 2015 is obviously a day that both Nathan and the Weber family will never forget. And in speaking with the Weber family before we came out here this morning, we both had difficulty understanding or wrapping our minds around the fact that in 2015, shortly to be 2016, we still find ourselves in court in cases like this with all the information out there about drinking and driving and what the family's lives that it destroys. It's just incomprehensible that we still have people in today's society that drink and get behind the wheel. The decedent here obviously can't speak to you, Your Honor. Chuck Weber, as they like to call him, Chuck, is Mr. and Mrs. Weber's first son. And I wanted to take a minute or two to let you know a little bit about him.
How old was it? Because I tried to find that out and I hadn't seen it.
44.
Thank you, sir.
He's 44 years old. His father was in the Army. He was born in Fort Knox. And he was very close to the family. He's very close with his nephew and his niece and spent a lot of time with them. He spent a lot of time with his mom and dad. He was in the trucking industry. He was a manager, a regional manager. And he would go home at least once a month, sometimes twice a month, to stay with his family. And over the last several years, he had forged a bond. And actually, I draw a comparison of myself and my father, the relationship that we have, that we've become very tight lately. That's what Mr. Weber had indicated to me, is that Chuck and he had become very close. He loved to be free. He wasn't married. He didn't have any kids, but you wouldn't know that from the sense of how much time he spent with his niece and nephew. He loved them very much. Loved to ride his motorcycle. As defense counsel indicated, there's really no words to put in perspective what we're dealing with here today. Mr. Weber summed it up perfectly in the back and said, but it goes beyond that, Your Honor. Mrs. Weber had a hard time when Mr. Weber was describing the facts, and I'm certainly not going to go through those facts of the case out of respect to Mrs. Weber, but I will say that this wasn't your typical, as Mr. Weber said, his son got hit, he bumped his head. He was dragged, and he died a gruesome death, and that's very unfortunate. They are very cognizant. When I say they are, I mean Mr. and Mrs. Weber are very cognizant of Mr. Heinz's age and that he's got his whole life before him. Mrs. Weber is Catholic, was raised Catholic. Mr. Weber is a Christian, or as he likes to say, he's Weberized. And they believe in forgiveness, and they have truly forgiven Nathan and want him to turn his life around. But at the end of the day, we still have a body. At the end of the day, Christmas is Friday. They never will be able to sit down at Christmas and eat with Chuck. And certainly my heart goes out to the Heinz family that they lost a member of their family as well. But at some point when Nathan's able to get back out into society, he will be able to go home.
Apologies may not change a person's life. People make mistakes, but some mistakes are unforgivable.
Thank you, for Your Honor, for letting me speak. I just wanted to say first and foremost, again, and I know I can't say enough, I'm sorry, the Webers. I'm so sorry. And you're right, you can't call it a mistake. It's a terrible decision, and I wake up every day just hoping that that's not what happened, that it's just this is all going to be done with, but that's not the case. The case is that this is my reality now, and this is something that I'm going to have to live with, just like they're going to have to live with. And my only hope is that I can share with other people and prevent more things, prevent more people making decisions like this, like I did, and just prevent some more senseless. That's it. Thank you, Your Honor.
Sometimes the judge becomes emotionally invested and bound to urge against committing a crime before delivering the sentence. This male Karen criminal claims to understand the law, yet he insists he's innocent despite stealing money from a bank. His arrogance only emphasizes his guilt.
The issue here was the enactment clause. All that was a diversion. I'm talking about the enactment clause under our Constitution. Okay. Right. Michigan Constitution, 1963, Article 4, subsection 23. What it states, it's mandatory, it's shall. Right. You know this. Mr. Rohr. Okay. I'm sorry, I'm getting high strong again. But I love the Constitution. Yeah.
Take it down. But no, I didn't know. I mean, I know I schooled you on it, but I didn't know you would then go and listen to me. So, all right. I just wanted to make sure.
Okay.
The statute would say we the people of the state of Michigan enact, and then would go into the statute. The complaint is then going to basically apprise you that you have violated this statute that the state of Michigan, or the people of the state of Michigan have enacted. So you've got that just a touch bit wrong.
Okay, correct.
All right.
But it should say enactment clause, because this lets me know the authority by which is decreed.
It doesn't have to. But go ahead.
It doesn't have to, but
No, it doesn't have to.
Your Honor, I'm not even in no position to say anything. You know the law, but
I do.
I'm just saying from what I'm reading in the Constitution and what it says and what Supreme Court justices have stated on the matter.
All right.
Okay? That's all I'm saying. I don't know nothing but what I read and what I interpret. I think I'm pretty intelligent enough to interpret the English diction.
Yes. Yes. All right.
Yes. So what you're telling me is that regardless to what, you're going to bend the Constitution to your understanding and how you want to rule it on this, and that you still obtain subject matter jurisdiction on a faulty, bogus complaint. Is that what you're telling me?
Mr. Moore?
Yes, sir.
In 16 years I've been on the bench, never bent the Constitution in any direction. Okay.
Freedom grants you choices, but not the right to take a life at will. Respect the line between liberty and recklessness.
Was impressed with. First, I will say that I am first and foremost concerned for the victim in this matter, Mr. Zhao.
Today's drama unfolds as Kelly Meadows takes center stage in court, confronting the repercussions of her actions along Detroit Avenue on April 17th, 2022. On that day, CCTV captured a chilling incident that will send shivers down your spine.
And where the vehicle flips, that's when the impact is made on the bus shelter.
This case reveals how one person's weirdness can turn another's life into a nightmare.
Anything from the state of Ohio?
Yes, Your Honor, thank you. On April 17th of last year at around 2:40 a.m., Ms. Meadows operated her vehicle eastbound on Detroit Avenue at 115 miles an hour. Her vehicle veered off the right side of the road and struck a pole at an RTA bus stop at 83rd and Detroit, completely obliterating the bus shelter. Lucas Zhao, the victim in this case, was sitting inside this bus shelter at the time of the impact. Following the accident, Ms. Meadows was observed to be having difficulty holding a steady gait and was slurring her speech. A chemical urine test was collected at the hospital and later conducted at the medical examiner's office. Her blood alcohol content was found to be 0.293, I apologize. Lucas Zhao suffered several serious injuries, including a skull fracture, several broken bones, including ribs, his jaw, his collarbone, his ankle, his back, and his eye socket. Furthermore, he had several serious liver and spleen lacerations. In fact, the emergency trauma surgeon on duty at the time still cannot believe that he survived this. Ms. Meadows also has a prior DUI conviction. Just to show the impact of the accident, the state would like to play 2 short 10-second videos for the court. The first video is a real-time crime camera video that was stationed at West 80th and Detroit. I'm going to briefly pause this for a second to give the court an idea of what's going on. So the bus shelter is up in this area. So you'll see her come around this way. And where the vehicle flips, that's when the impact is made on the bus shelter. Now the second video is from a different angle at West 85th and Detroit. So, let me pause it again. So over here is where the bus shelter is in this video. I hope the court understands that this was a purposeful action committed by Ms. Meadows. She knowingly and willingly consumed alcohol, and she knowingly and willingly got into her vehicle and drove. Both Lucas Zhao and his parents, Wendy Wang and Jun Zhao, had prepared victim impact statements that I'd like to read for the court on their behalf. They are appearing via Zoom. This first letter is from his parents. Dear Judge Bell, Lucas was almost at the proudest moment of his life. 4 years of computer science education at Case Western Reserve University were almost complete, and he was just a month away from graduation. He had successfully secured a job in his field almost a year before his accident and was looking forward to starting a career in the computer science field. He was ready and excited to go to work. Unfortunately, while waiting for a city bus on the night of April 17th of 2022, both his body and future were breached by the negligence of a drunk driver.
You may not value the life you're taking, but hearing from their loved ones reveals their true worth.
She has not only been there for me, but she's been there for my family. And she's been an example to our family. I actually work in healthcare after Kelly became a nursing home administrator. She talked with such passion about how fulfilling it was to help people And after I went back to work, after being a stay-at-home mom for a time, I remembered her words, and I remembered, gosh, if I'm going to leave my kids, if I'm going to leave my home, I want to feel like she feels. I want to help people. And from there, my own daughter became a nurse. So healthcare, just began with her. And I also want to say that she is there for her family, and her family needs her. Not only can she be a productive person in our society, but her family relies on her. And lastly, I would just like to also say that Kelly knows that myself and my family, we do have a strong prayer life. And the first thing that Kelly said to me was, please pray for Lucas. Please pray every day. Pray like you've never prayed, that this young man will have a life and a future. And I have been praying, and I believe that he will. And she is very remorseful and understands what has happened, and it will never happen again. I thank you for letting me speak.
Thank you. Sure.
In the realm of justice, the judge, backed by evidence, delivers a sentence that brings comfort to the victim's family.
There have been a lot of mitigation here presented before the court. At least 23 letters, which the court has reviewed. In those letters, the court will make note of some things that the court specifically was impressed with. First, I will say that I am first and foremost concerned for the victim in this matter, Mr. Zhao. As the defendant has explained, it is Mr. Zhao here who should be thought of primarily and always in this matter. He is the victim on this offense. In reviewing his statements before the court was very impressed with his brightness, with his...
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.